1 officer, 2 officers, 3 officers, 4, 5,
Way down.
6 officers. Look at all these officers. And then you got a whole crowd of code enforcement officers. This is like police.
Oh, look. The first guy. Display of indecent. Can't wait.
We have Paul Seculato, Edward Manning, Henry Bauman, Roland Erickson, and John Colifax. Looks like Colifax. And at the table we have Jay Nadelson and Nora Gardino.
Interesting. You're right. You can watch it.
I will call the meeting of the Code Enforcement Board for the City of Punta Gorda to order today. As a preliminary matter, I ask all of you that have cell phones, would you please turn them off? Put them on vibrate if you're expecting a call, but I do not want to hear any ringing, please.
Sure.
Would you please take the roll?
Edward Wiener,
Here.
Paul Seculato,
Here.
Jane Abelson,
Present.
Nora Jardina,
Here.
Roland Erickson,
Present.
Henry Bauman,
Here.
John Shalvo.
Present. Minutes for the last month's meeting have been distributed. Motion. A motion to accept the minutes. Motion accepted.
Comments?
Pardon?
Comments?
For the minutes?
Yes, right.
Yes, if you have any additions.
So on the last page of the minutes, there's a discussion about the case that was being presented today. And Mr. Levin explained to the board that the board would make a determination based on the evidence and testimony presented and not on the constitutionality and legality. Just wanted to be clear, it's not clear in the minutes that at that time, Mr. Levin was speaking as a prosecutor and not as the advisor to the board. And I think the minutes show that.
You please, that he was speaking again is what, Mr. Nelson?
Sorry?
Say again what your concern was.
Well, my concern is that it's not clear in the minutes who Mr. Levin was representing when he made those comments about the role of the board. And he was speaking as a prosecutor, not as the board's counsel.
Mr. Levin, would you care to comment on that?
I think I was speaking generally as a city attorney, not with respect to a case that was at that time before you, but I think the point is well taken, that as this case is going to be heard today, I am the city prosecutor and not advisor to the board, and David Jackson is here, who is the advisor to the board, and any comments that I make would be considered to be argument and not advice to the board.
And so we should reflect that in the
I
minutes?
think that would be helpful, yes.
We hear a motion to amend it?
I guess I'd make a motion to amend the minutes to reflect that Mr. Levin's comments were not as counsel to the board, but rather as the city attorney and representing the prosecution.
I think the minutes ought to be amended just to reflect all comments during that session. Because it's very generalized.
That's acceptable.
Okay.
So I withdraw my second to the motion to approve. And I'd like to see the minutes amended before they're approved.
Okay.
I'll amend my motion to reflect same.
Here we have an amended motion to indicate that the parties speaking that thing were, as you said, John, just in general.
Yes, it was a generalized comments according to the meeting. So I think the minutes ought to be amended to reflect exact comments.
We all understand the motion as prepared.
And if I might just state a little bit further, so that the record is abundantly clear. The discussion had to do with the questions regarding the interpretation in general of the recently adopted sign ordinance. And the questions were being posed to me as the city attorney who had a hand in drafting those ordinances. And therefore, as I said, it was of a general applicability based on the interpretation of the code and the Code Enforcement Board's responsibility and obligations and jurisdiction to enforce those provisions, which was in the nature of general comments made in the context of the city attorney, not as the prosecutor in any particular case.
And specifically, I had made a comment that it is not the board's determination whether the ordinance is legal or not. Our job here is to determine whether a specific ordinance that has already been passed by City Council has been violated or not. If the ordinance has been violated, then we find the respondents guilty.
Right.
Once again, I'll amend my motion to reflect what Mr. Schofield has described.
I think the amendment should be for that section of the minutes that the comments contained therein are of a general nature of the parties on the matters that will be considered.
I'll amend my motion to what he said.
Okay. As presented, all those in favor of the motion?
Do you have a second?
I thought we did.
Second, Giardino.
Okay.
We have a second. If we do, then as the motion presented, all those in favor signify by saying aye.
Aye.
So you've accepted the amendment, and you have a vote again on approval of the minutes as amended.
Okay. I'm requesting a motion that we approve the minutes as amended.
So
Motion has
moved.
been, and it's so second.
Second.
Any discussion on the motion? Further discussion? Hearing none, may have a vote. All those in favor?
Aye.
Any opposition? Okay. As amended. You have it.
I will want to go back to the recording.
Probably. Next meeting is August 18th, and we'll get into the substance. All those who plan to speak before this board, would you please rise and be sworn? And as you testify, would you please indicate that you have been sworn?
Anyone intending to offer testimony in today's proceedings, please stand and raise your right hand. Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth in today's proceedings?
I do.
Right. Can you take a seat? If you are ready to speak, please come to the podium and state your name and indicate that you have been sworn. And I would ask all members to please make sure that they are speaking directly into their mics. It's a little hard to hear at times. Could you please move yours a little closer to your mouth, Mr. Nicholson?
Okay. First case, contest of citation 20-5071, case number 21-79906. Police officer William Gorman, badge 711. Respondent Andrew Bryant Sheets, violation of Chapter 9A, Section 9A-13, Sub C8, and violation of Chapter 26, Section 11.1, Subchapter Z, display of indecent signs.
Mr. Chair, that was, should have been
I'm sorry.
section 11.5.
As corrected, 11.5 Z, display of indecent signs. Mr. Sheets present?
Yes. Mr. Chairman, I'm Ferris Heindel. I will be representing Mr. Sheets in this proceeding. Attorney.
Yes.
Thank you.
Mr. Chair, before we begin, got an indication we want to have a little discussion on some preliminary matters regarding this case and the next 4 cases on your agenda. We could go through that and make this discussion, this preliminary discussion.
Excuse me,
Yes.
please state your name.
Oh, I'm sorry, David Jackson,
Thank you.
advising the board here this morning. So yeah, my intent is we have a little discussion on some preliminary matters regarding these cases and have this discussion be part of the record for each of the first five cases on your agenda to avoid duplication, if that pleases the board.
That sounds fine with me.
Okay. So again, just give a little background on how we got here. A lot of this is in your agenda, but just make sure we're all on the same page. Respondents in these 5 cases were issued citations for alleged violations of Chapter 26, Section 11.5Z pursuant to Punta Gorda Code Chapter 9A10. In accordance with Section 9A10D, the respondents timely filed written notifications with the city indicating their intent to contest the citations. Each case, the city issued an affidavit of violations and notice of mandatory hearing. Pursuant to Chapter 9A, Section 9A10G, the respondent's election to contest the citation serves as a waiver of the respondent's right to pay the fine initially assessed in the citation. And if the Code Enforcement Board finds a violation, the board may assess a fine and cost in accordance with Section 9A8. So you received some information regarding each of these 5 cases, and I want to try to clarify what exactly is in the Code Enforcement Board's purview as the triers of fact for these matters. It's your job to consider the evidence and the testimony presented to establish findings of fact, conclusions of law, as to whether violations set forth in these citations occurred. And if so, determine whether and how much of a fine cost should be imposed. And that's it. Again, while you receive some written materials regarding the constitutionality of the ordinance alleged to have been violated, determining whether or not the ordinance is constitutional is not within your purview. It should not be part of your determination. You don't have the authority to overrule City Council's decision to pass the ordinance. Further, the law provides that the proper form to address any such constitutional claims is through an appeal to the circuit court.
Mr. Jackson, what
Yes.
does the city need to do to establish a prima facie case?
I'm sorry,
What does the city need to do to establish a prima facie case?
I'm not here for that. So again, Section 11.5Z is what's at issue here, and it provides that no person shall erect, display, wear, alter, maintain or relocate certain specified types of signs in the city, which includes any sign which contains obscene language or graphics, and any sign containing fighting words or indecent speech, which is legible from any public right-of-way or within any public space, and which potentially can be viewed by children under the age of 17. So now the citations at issue here referenced indecent signs. In order to find a violation, you must look at the evidence in the code language and determine if the sign in question included indecent speech, which under the code is defined as language or graphics that depict or describe sexual or excretory activities or organs in a manner that is offensive as measured by contemporary community standards.
How are contemporary community standards established in this case, and does the city have an obligation to establish those before we can proceed?
That is, I don't believe there's any definitions of contemporary community standards in the code. So
Well,
that is it.
there are community standards established by the Supreme Court.
Well, that's that's what the board's determination is that this is.
So you say the city does not have an obligation to show that they violate, that they go beyond the community standards when that's a very vague concept. I don't see how we can find a prima facie case until we can determine what community standards are.
Well, that's the board's discretion to determine what the community standards are. That's what you're doing here.
So there's no legal definition here.
What we say.
I'm not aware of one.
I mean, we're looking for you as help as our counsel.
I do not have a definition of what contemporary community standards are. That's a determination to be made by the board. Perhaps the parties will have some input on what that means. I imagine that would be part of their case. Again, that's the first element. If you make that determination, was the indecent speech legible from any public right-of-way or within any public space? That'd be the second element. And then finally, could the indecent speech potentially be viewed by children under the age of 17? And that's all I have.
Constitutional issue, yeah.
Okay.
I know you received a memorandum
You guys think they're God.
from the defense counsel representing all the defendants, or the respondents in all 5 of the cases. And the city's filed a motion to strike that.
Yeah.
And the board's discretion, how you want to handle. If you want to have discussion regarding that motion, hear from the parties regarding that motion. To do that at this time, again, make that part of the record for each of the 5 cases. That'd probably be appropriate.
May I respond to the motion? If it's actually a motion, it should be a response. In typical court procedures.
You want to address the motion first and then have them respond?
Certainly.
Okay.
For the record, David Levin, City Attorney, and I'm acting in capacity as the City Prosecutor. As you are aware, the Defense Counsel filed a memorandum of defense on behalf of the respondents in this case. The principal argument made in that memorandum was contesting the constitutionality of the ordinance that has been cited to be violated by the respondents. I filed a motion to strike a memorandum of law in support thereof, presenting the argument that this is an administrative tribunal that has very limited jurisdiction, clear jurisdiction separate and apart from the jurisdiction of the courts. The case law that I cited in my motion and memorandum in support thereof identifies that it is very clear that this is a quasi-judicial body, not a judicial body. And the function of this body is to consider the facts in light of the ordinance, but not to have any authority to make a determination of the constitutionality of the ordinance. That is strictly the purview of the courts, particularly the circuit court, which would be the first avenue of appeal of any decision that you make today. So to the extent that the memorandum of law submitted by the defendants presents a defense based on the constitutionality of the ordinance. I would submit that it would be inappropriate for you to consider that. And I also argue that it might even be a violation of the Florida Constitution for you to, as an administrative body, go beyond the scope of your jurisdiction and render an opinion and a decision based on your understanding or belief of the constitutionality of the ordinance. And so I moved to strike that memo so it wouldn't be considered by you in your deliberations. It would not be part of the record in your deliberations, so that the record would be clear that whatever finding that you make is not based upon the constitutionality of the ordinance, but whether or not the evidence is presented and the text of the ordinance, in your opinion, constitutes a violation of it. Thank you.
Mr. Jackson, I have a question for you.
May I respond to that too?
I've got a question
Oh, I'm sorry.
for our counsel.
Let's,
Would you like to hear from?
Well, the question is whether or not, I received the memorandum at 4 o'clock in the afternoon yesterday, as a motion was with a lot of backup material. Is it fair or is it appropriate for him to respond at this time?
Yeah, I believe it's fair if he wants to, like him to respond. I think he's prepared to make a response.
May I respond to counsel Attorney Levin's
Could you
argument?
go to the podium, please?
please, the podium,
The
the
podium.
microphone is. Thank you.
That would be the chair's decision.
Okay, great. I'm not familiar with your proceedings here, so
Well, this is all not up to us, so, but yes, you may respond.
I will be asking you questions along the way, like may I cross-examine the witnesses and so forth. But as far as the memo is concerned, lawyers have to be very careful. Appellate courts are always saying if you don't make the argument in the lower tribunals, you waive them in the higher tribunals. Mr. Levin will verify that, I think, in all candor. So that's a standard protocol. Attorneys must and are always careful to make all arguments possible. So at the very minimum, I'd like for this memo to be part of your record so that any appellate courts, any higher jurisdictions would know that these arguments are made. As far as striking them, I certainly can't say anything about the jurisdiction. Attorney advisor said you don't have jurisdiction to determine the constitutionality. I'll have to agree with them, not that I know I'm ready to prepare to argue the law on that, but they're your court advisors, so certainly you have to take that position. But you have no authority to determine this ordinance is unconstitutional. However, you don't have to read the memo or look at the memo in view of, hey, I've got to determine the legalities of here. I don't know if any of you are lawyers, but it's difficult. You don't have to read the memo in that light, but certainly you can view the memo as understanding that the reason Sheets and Massey are so adamant about what they're doing is because there's a very strong argument that these ordinances are unconstitutional. It's not a fly-by-night, crackpot argument. Now this goes to why they did what they did, the motivation in their sign, the wording in the sign. There's no facts without context. So the context that these gentlemen are not only here to exercise these rights, but to stand for the whole rights of the community is in a sense validated by the memo. Although you can't determine whether it's constitutional or not, you can say, well, there is a strong argument that this ordinance is unconstitutional. So that would go to the way you view the facts. So that's my response here. There's no need to strike it, but you don't go so far as to determine the constitutionality. It's just part of the record. Thank you.
Mr. Chairman, if I might respond?
Yes, you may.
So I understand what counsel is saying with respect to wanting to make sure that if and when he takes an appeal to the appellate court, he makes it clear to the court that he wasn't raising the constitutionality of the ordinance for the first time on appeal. Courts generally require that you exhaust your administrative remedies. And so I'll stipulate for the record that the defense counsel is making an argument with respect to the constitutionality of the ordinance. However, it is not appropriate for you to consider the argument that there's a strong and compelling argument to be made by the respondents that the ordinance is unconstitutional. That's not within your purview, as I indicated, and the record needs to be clear as to whether the determinations that you made today are based strictly on your findings of fact as it relates to the testimony and evidence presented today, and whether based on that evidence and testimony as a conclusion of law, it's a violation of the ordinance, and that the whole question of the motivation of the respondents, their belief with respect to the constitutionality of the ordinance are irrelevant factual matters for your consideration today.
Mr. Chair,
Yes?
I'd like to make a motion.
Let me just make one comment before we get to a motion. I realize, as Mr. Nettleson said, some of this stuff came into us at the 11th hour, and a lot of us have responsibilities beyond this board. And when emails come in, I don't know about all of you, but I don't live attached to my computer. So when it comes in, it's almost, again, the 11th hour that I'm reading this. And I would ask that we have a motion that we accept these documents for the record, but that the board take no action on them and just include them for the purposes of our hearing. Would you entertain that as a motion?
My motion would be to strike the memorandum of defense to citations and memorandum of law in support of the motion.
Motion has been made. Is there any second to that motion?
Seconded.
What exactly do you expect to achieve from my discussions as we have a second?
Well, my motion is pretty clear that as our attorneys have advised us, I don't think that this has any precedence in this case. Again, I reiterate that our job on this board is to hear the case of an existing ordinance, which is now before us, whether it was violated or not. Whether the constitutionality of this case is relevant, whether I agree with the constitutional relevance of this case, it's totally irrelevant. So,
Well, I will tell you, I would speak in opposition to your motion because I think since we have received documents from both parties, and it is probably, most likely, that all of this matter will be going forward to a court, that I would just as soon incorporate all these documents into this board's record and let the courts handle it from thereafter rather than strike anything and not include it within our file. So, any other discussion on this motion?
I'd like to add that, I didn't, again, receive this document in my email until late in the evening last night, and I printed it out and started reading and probably until midnight. I was up at 7 this morning and still couldn't get through it because I didn't have time to. So this is the 11th hour motion. I would agree that to leave them in there, but not to strike the initial motion, because I don't think any of us have had a chance to read the motion to dismiss.
Any other discussion?
Yeah,
Yes, please.
I'm David Jackson. For the record, my advice to you would be to, I think the points from both counsel were well taken. My advice to you earlier was, I think, very clear that the constitutionality of the ordinance should not be part of your determination. However, I would recommend that you leave the memo and the motion as part of your record going forward. But again, to make it clear on the record, my advice to you is your determination in these cases needs to be based on the testimony, the evidence, applying it to the ordinance, and not focusing on the constitutionality of the matter. That is to be decided in another forum.
Is it possible that because many of us have read it, that it could be concluded that the memo's contaminated the decision of the board?
Well, anything is possible, but again, I would just encourage you when making your determination, whether it's to find a violation or not, that it not be based on, we believe that the ordinance is unconstitutional. You need to find that it either met the elements as we went through, or it didn't meet the elements. And not look off to this other issue that's out there to be determined in another form.
I'll amend my motion, that we will,
Okay, so nobody,
That was mine.
so the motion has not been seconded, and we're going to leave it in there.
Yes.
I think it's appropriate just to move it forward as being discussed as part of the record.
As the motion has been presented, any further discussion? Take a vote. All those in favor of the motion as presented, please signify by saying aye.
Aye.
Any opposition?
Nay.
One nay.
Okay,
Motion
again, if I
carried.
could just indulge me for a minute. I think we're ready to move into the facts of the first case. So if I could state on the record that that preliminary discussion we just had will be part of the record for each of the subsequent 4 cases on the agenda.
Yes.
Thank you. Unless we want to repeat it 4 more times.
No.
May I inquire as to how this proceeding should go? Do I get to question the...
What will happen is we will have your client plead whether he is guilty or not guilty. We will have the city present its case. There will be discussion. You will have an opportunity to ask questions of the witnesses. Will you be presenting witnesses?
No, I have no plans for it.
That's fine.
Counselor, if you're going to talk, you got to do it in a microphone at the podium.
Yes, over here, please. So
I'm not talking now. I think you start with the
Okay.
statements.
Well,
correct?
doesn't matter. We'd certainly like to have your questions answered, but your client can take the podium.
Are you whispering now? Or you're not talking now?
I'm sorry, maybe you can't hear me. I was trying to get a handle on the procedure this court's going to
Yes.
follow.
Can you please state your name for the record?
My name is Ferris Heindel. I'm an attorney for Mr. Sheets and Mr. Massey.
And you've been sworn?
Well, I'm not going to be testifying. I'm going to be arguing. Typically, attorneys aren't sworn. But we're to be officers of the court, and what we say is mainly argument. It's not facts. Sworn fact witnesses get sworn.
Mr. Chairman, I would agree with that. I have not been sworn either as a city attorney.
I know.
And I also want to point out, Counselor, we're recording this proceeding, and the microphone is that little black thing on the podium there, and the microphone is more or less limited in its scope of being able to pick up audio. So I want to make sure that you understand that anything that you say in this proceeding needs to be recorded, and that's why we're asking you to stand at the podium.
Very good. I'd like to make a closing at the appropriate time once the witnesses have been presented and questioned.
Just,
Nothing further to say right now,
but
unless you have questions
This
for
is a
me.
request. Closing could be succinct rather than elongated if you want.
As succinct as I possibly can be.
Thank you.
That may not be that succinct. I'll try. Thank you.
Well, if you want to stay with your client when he's at the podium?
I can, certainly.
Yes, my name is Andrew Sheets.
Just before,
What's that?
we were slightly interrupted before we got to the stage.
All right.
The charges were presented, and you either, our mission would be guilty or not guilty.
Not guilty.
Thank you.
My name is Andrew Sheets. I have been sworn in.
Okay, that's fine.
Can I do my opening statement?
Not yet.
All right, sorry.
I'll give you the buzzer when it's your turn.
All right.
Would the city please present its case?
Mr. Chairman, have you actually opened the case by reading the charges?
Yes, we did.
All right, thank you so much.
Then we had a preliminary discussion, so we took a break from that.
Thank you so much. I'd like to call our first witness. Would you please state your name for the record?
Officer William Gorman, Gorman.
And by whom are you employed?
I am employed currently with the Punta Gorda Police Department as a police officer, and I have been sworn.
And what are your duties and your responsibilities as a police officer?
As a police officer in the state of Florida, our duties and responsibilities would be that of enforcing laws, preventing crime, responding to emergencies, providing support services, and assisting in mitigating emergency situations.
And in the laws that you are responsible for enforcing, does that include ordinances of the city of Punta Gorda?
Yes, sir, it does.
And were you so employed on June 9th, 2021?
Yes, sir, I was.
On that date, did you receive a request to respond to a potential code violation at 410 Taylor Street?
Yes, sir, I did receive that dispatch call.
And is 410 Taylor Street within the territorial limits of the city of Punta Gorda?
It lied within the city of Punta Gorda.
And did you in fact respond to said request?
Yes, sir, I did.
Are you generally familiar with the city's sign standards contained in Chapter 26 Punta Gorda Code?
I am, sir.
I'm on the screen is our exhibit number 1. Do you recognize exhibit number 1 as the definition for the term sign as contained in the city's sign code?
And yes, sir, I do.
I'd like to show you city's exhibit number 2. Do you recognize exhibit number 2 as the definition of the term indecent speech as contained in the city's sign code?
Yes, sir, I do.
Then I'll show you city's exhibit number 3. Do you recognize exhibit number 3 as one of the types of signs prohibited by the city's sign code?
Yes, sir, I do.
I'll show you exhibit number 4. Does this photo appear to be taken from your body camera?
Yes, sir, it does.
And does this photograph appear to be an accurate depiction of the scene upon your arrival at 410 Taylor Street on June 9, 2021?
Yes, it does.
Where were you standing when the photograph was recorded?
At this point, I'm exiting my city patrol car, and I'm approximately 10 to 15 yards away from that particular individual.
Were you standing within a public space?
I was in the parking lot, center of the parking lot.
And is that a public space?
Yes, sir, it is.
And what building is located at 410 Taylor Street?
410 Taylor Street is the county tax collector's office, the driver's license office, and registration office.
Is that a facility that has members of the public coming and going throughout the day?
Absolutely.
And who is the person that's facing you in city's exhibit number 4?
The individual facing me there is Andrew Sheets.
And how are you familiar with Andrew Sheets?
Through the course of interactions with as a police officer within the city.
And I'll show you city exhibit number 5. What is Mr. Sheets, is that Mr. Sheets depicted in exhibit number 5?
Yes, sir, it is.
And what was Mr. Sheets doing in this photo?
He was holding up that particular signage, a flag, if you will.
And is the photo an accurate depiction of the scene as you saw it at the time?
A true and accurate depiction of what I observed.
Was Mr. Sheets standing within a public space?
Yes, sir, at that he was.
Was Mr. Sheets holding a sign as that term is defined by the city sign code, as you understand it?
Yes, sir.
Did the sign that Mr. Sheets was holding contain indecent speech as that term is defined in the city sign code, as you understand it?
Yes, sir, it did.
And what word or words on Mr. Sheets' sign did you find to be indecent speech as that term is defined in the city sign standards?
It would be the black letters above the word TRUMP, and that word phonetically would be F, Frank, U, Union, C, Charles, K, King.
What was the approximate time of day of your observations of Mr. Sheets?
This was approximately 9:30, 9:40, before 10 a.m.
Was Mr. Sheets holding his sign in an area where his sign could potentially be viewed by children under the age of 17?
Yes, sir.
I'll show you city's exhibit number 6. What was Mr. Sheets holding in his right hand?
In his right hand was what appeared to be the Punta Gorda City Council photograph with some verbiage written within that photograph.
And did the sign, and for the record, I've enlarged a portion of exhibit number 5 to focus, number 6 to focus on a specific sign that we're speaking of. Did the sign that Mr. Sheets was holding in his right hand contain indecent speech, as that term is defined by the city sign code?
Yes, sir.
And what word or words on Mr. Sheets' sign did you find to be indecent speech, as that term is defined by the city sign standards?
In the second row, you have the letter R. The next word would be phonetic spelling, C as in Charles, U as in Union, N as in Nora, T as in Tom, S as in Sam.
Was Mr. Sheets holding the sign depicted on city's exhibit number 6 within a public space?
Yes, sir.
And was Mr. Sheets' sign that he was holding in his right hand in an area where his sign could potentially be viewed by children under the age of 17?
Yes, sir.
And I'll show you city's exhibit number 7. And what is Mr. Sheets wearing?
At that time, a black t-shirt with black style white lettering.
Is the photo an accurate depiction of the scene as you saw it at that time?
Yes, sir, it is.
And is Mr. Sheets' shirt considered to be apparel?
Yes, sir.
Is it your understanding that apparel upon which words have been printed constitutes a sign, as that term is defined by the city's sign standards?
Yes, sir, it is.
Did Mr. Sheets' shirt contain indecent speech, as that term is defined by the city's sign standards?
Yes, sir, it did.
And what word or words on Mr. Sheets' shirt did you find to be indecent speech, as that term is defined by the city's sign standards?
On the back portion of the shirt, as we look at it there, it would be the white letters, top word, again, phonetic spelling of that top word would be F as in Frank, U as in Union, C as in Charles, and K, King.
Was Mr. Sheets wearing the shirt depicted in city's exhibit number 7 within a public space?
Yes, sir.
And was Mr. Sheets wearing the shirt in an area where his message could potentially be viewed by children under the age of 17?
Yes, sir.
Did you ascertain whether or not Mr. Sheets had previously received a written warning from the city for an alleged violation of Chapter 26, Section 11.5Z Punta Gorda Code?
Yes, sir. I had knowledge of that warning that was issued.
In fact, wasn't Mr. Sheets issued a warning on June 7, 2021 for displaying a sign with indecent speech within the city of Punta Gorda?
Yes, sir, he was.
I'll show you city's exhibit number 8. Is that a true and accurate copy of the citation you provided to Mr. Sheets on June 9, 2021?
Yes, sir, it is.
Mr. Chairman, at this point, I would move to enter exhibits 1 through 8 into the record.
Accepted.
I have no further questions and would offer Officer Gorman for cross-examination.
Thank you. May I proceed?
Yes.
I don't have an overhead, it'd be a little easier, so I might ask Mr. Levin to throw up some of his exhibits if he would.
Yes, sir.
During this process. Officer, you're familiar with the actual ordinance based upon this charge, are you not?
Yes, sir.
Do you have a copy of the ordinance there, Mr. Levin?
The entirety of the ordinance, yes.
Just the body of the ordinance, not the definitions.
Yes.
Okay. Can you put it up on the overhead?
Well, what are you looking for? I've got a copy of the entire ordinance. I don't have an exhibit of the entire ordinance.
May I,
The exhibits that
may
you
I
just-
approach? May I show you what I'm talking about?
Yes, thank you.
It's easier than trying to describe it. Keep this or use this, but just the actual body of the ordinance. This is the actual body. This is the actual relevant section.
That's here. That would be exhibit 3, correct? Is that the one you're referring to?
Yes, sir. That would, correct, correct. Now, in order to do your duty as a police officer, you've got to fairly and apply the wording of these ordinances and their definitions. Is that correct?
Yes, sir.
Okay. So some of my questions are going to be as to whether these wording of the definition were fairly applied, because it's the board here that's going to be making a decision based on the ordinance. You don't expect the board necessarily to adopt your version of what these words mean and say, do you? You're not expecting the board to have to accept your understanding of the meaning of the words and the definition in this ordinance, are you?
My expectations about what their belief is, I can't comment on that. I
Okay.
can only comment on what our instructions were, what our memos were, and what words in those memos were enforceable.
Okay, would you agree with me then that the board can read these definitions in the ordinance for themselves, apply the facts to the ordinance to determine for themselves anew whether there's a violation here?
That could be possible.
Okay. Now, in this ordinance, it says, "in which can potentially be viewed under the age of 17. Did you make a determination whether their signs could be potentially viewed by people under the age of 17? Did you make that determination?
That determination was based on the public access to the area where we were.
Okay, so would you agree with me that any public access, wherever you are in any public area, no matter where it is, a legible sign can be viewed by anyone less than the age of 16?
I object to the relevancy of the question. The question, he's seeking to contest the actual language of the ordinance and its applicability elsewhere. We have before you testimony regarding the specific location, time of day, and sign that was at issue in this case, and he can certainly render an opinion based on where it was that he viewed the potential violation, not with respect to any type of other hypothetical situation.
Mr. Jackson, since there's no one judge here and we're a group of 7 people, how are we to respond when there is an objection?
I will handle that as chair.
Well, we might all have an opinion.
Well, right now, it's,
I'm asking our counsel as to what the proper procedure is.
I would defer to the chair if he wants to get board input on it, or my advice on it, that's fine.
do we want to spend time on a discussion on this, or you accept my decision? Okay, do you have any further comment on?
Just a very simple question to be answered very simply. Wanted to know, and the reason is, we need to understand this ordinance in order to apply it in this particular fact situation. We need to understand the meaning of the words. That's what our government's about. We lay out laws, and if they mean something, they do. If they don't, if they're too confusing, that's an issue. In this case, he has to make the determination whether the signs can be viewed by anybody less than 17. So I just want to know, is there anywhere, any place on earth that's a public area, or rather not on earth, in Punta Gorda, that a sign, a legible sign, cannot be viewed by somebody that's 17? The answer is no.
I think, your question obviously is extremely broad in that area for this individual to answer, so I'll agree with City Council that the motion should be, or what he requested.
It's irrelevant. It's irrelevant.
So what exactly did you do to make a determination that this sign could be viewed by anybody that's under the age of 17?
Based on the ordinance, which clearly stated that could be potentially viewed by a person under the age of 17.
I mean, what did you do to make that determination? You have to make a determination or the ordinance doesn't apply, correct?
Mr. Chair.
You received a voice note.
I'm probably the dumbest one here in the room, so I'm going to ask some really stupid questions. Have you ever been to the facility on Taylor Road that Officer Gorman has spotted the signs? It's a simple yes or no answer.
If I may, let's finish this cross-examination, and then you'll have an opportunity to question the other witnesses.
Just a simple question, sir. Did you make the determination, yes or no? I've got one follow-up question after that. It's very simple. Did you make the determination that these signs that you've been referring to could be viewed by someone under the age of 17?
Yes.
And what did you do to make that determination?
It was common knowledge. My knowledge allowed me to make that determination because of the public place, the public property that it sat on.
Because it was public property, okay? So in order to find a violation here, you've got to find one of the three things. That the sign contained obscene language or graphics, and any sign or fighting words or indecent speech. Is that the way you understand the ordinance? Is that the way you understand the ordinance?
Did you read that exactly?
I didn't read it verbatim. It's right up here. You're going to have to find it's obscene, or it has fighting words, number 2, or indecent speech. One of those three.
Yes, sir.
Right? Did you find any obscenity in the signs? Obscenity.
Excuse me, I object to the question because it's not relevant. The charge in this case was that the respondent was holding an indecent sign as defined in the code. He was not charged with having a sign with obscene language or graphics, nor was he charged with a sign having fighting words on the sign. So the question should be limited to whether or not he determined that the sign contained indecent speech, because that's the relevant inquiry.
Okay, so now I understand what the charges are.
Okay, I will accept your objection.
Thank you.
Okay, now all we have to, that's very good, sir, because now we can just focus on the indecent language, correct? council here doesn't have to even consider the definition of obscenity or fighting words in making their determination. Do you agree on that?
Yes, sir.
Okay, very good. I'm trying to be succinct and fully represent my client, sir.
Hold on, just a second. Mr. Nielsen, you need to, I'm been advised by the clerk that they can't hear you. You need to move that microphone close to your mouth.
I didn't say anything.
You previously had.
Oh, okay.
Thank you, sir. Sorry for the interruption.
Okay, so let's look at the definition of indecent, please.
That'll be exhibit number 2.
Here we go. I apologize to this board and anybody listening or recording if I use language that I wouldn't otherwise use. I don't know really how to get some of my points across. And I don't use that type of language, but I may have to use some F words or whatever to get my points across. Okay, let's look at the definition of indecent speech. Language or graphics that depict or describe sexual or excretory activities or organs in a manner offensive as measured by contemporary community standards. Now, in order to find that those signs are indecent, officer, counsel, that there has to be a finding that the signs actually depict or describe sexual or excretory activities or organs. Would you agree with that? That you have to make that finding?
Yes, sir.
Okay. Now, each word would you agree with me that each word in this definition is important, such as it's important to understand and apply the word depict and what that means? What, do you have a definition of depict, sir? Let me see if you agree with this definition. I pulled it off the Webster's Internet. You depict something, someone or something, you show what that person or thing is like, either with some kind of image such as a drawing, painting, photograph, or movie, or with words. You show what something is like. And would you also understand that the word described is important? Do you have a definition for described that you apply when viewing this ordinance and its definitions? Sir?
Yes, sir.
What's your definition of described?
The description of the word itself has been placed in a memo that says if those words appear, and they're clearly spelled out to the officers of this agency, that would be in violation. And that memo clearly used the F-U-C-K and the C-U-N-T word, and that's what we based this off of, because it was a 34-page ordinance. So with the assistance of the city, they elaborated and told us what words would be in violation of that. And so now if you ask me to describe or to define certain things, I do not have a dictionary here with me, but I do have the city memo that says what we will enforce.
Okay, so I think it's important to me and this board to know that when you look at this, you're going by what you were told to say this means and not what you thought it means. Is that correct?
This is neither the time or place for my opinion.
Thank you.
Like you stated earlier, Counselor, there's certain words that I will say, but that's me.
Well, the board, this board is not going to get that memo. It doesn't have to go by this memo. Would you agree with that?
Mr. Chair, I object to being schooled in English 101. I mean, this is a total waste of time.
Thank you. Could you move on? I mean, we are dealing with things we have general knowledge, ordinary
Very well.
definitions.
I'm trying to make it clear that the board's reads for itself and doesn't...
Yes, I
Okay.
think the board, if I can speak for the board, I think we know what the word depict and the word describe means. And we don't need a dictionary definition.
Well, I understand that you don't have to go by the memo as well. Thank you. I don't want to waste your time, sir. The lawyers have
Doing
to...
a good job of it.
Thank you.
Continue, please.
All right. Let's take some words using a fuck. Okay. Well, let's stick with the words they're words that are commonly used with fuck. It doesn't have any sexual connotation like fuck off, what the fuck, fucking idiot. You don't think when using those words people are actually trying to get out a description of sex, do you?
Mr. Handel, again, if you don't mind, the board one, same time. I play golf, so I hear a lot of phrases using that term, but it's a phrase. It's not the signs that we're dealing with. It's the description, as the sign said, or depiction. Let's stick with the sign and the language on the sign.
And see,
Mr. Chair, and since council is having a difficult time with the English language, the word offensive in the last line is where everybody's heading. So what the fuck may be offensive to most of the people in this room? It may not be offensive to the two bozos sitting here.
Your Honor, I move to disqualify this gentleman from this proceeding and demonstrating animosity toward counsel, prejudgment.
Send me to the electric chair, Counselor.
No, I think he should be disqualified from this
Eject him.
proceeding.
Let's try to keep the personal comments down.
Advisor?
Focus on the issues, please.
Mr. Chair, if there's no other direct questions for the officer that we haven't already heard, I think we need to go ahead and wrap this up and decide whether we have a prima facie case.
I agree with you.
Sorry, not completely
But,
not fair with that.
Well, but I do want to make sure that they have an opportunity to present their case fully and fairly. So,
This gentleman here displayed what's exactly, when you interpret this thing, you don't just say, hey, was fuck you offensive? You have to determine whether fuck you actually describes sexual or excretory activities. Okay? It's just a phrase used.
Mr. Chair, again, I must strongly suggest that if the counselor doesn't have a direct question for the officer, that we proceed.
I have a lot of direct questions, sir. I'm just getting objections and interference from board members. It should be disqualified
Mr.
because they've already
Heindel, would you
prejudged the
please
case
get your questions?
and exercise animosity. I haven't shown any animosity to anybody in this room. Hadn't insulted anybody. I'm simply stating my case. A member should not sit on the code enforcement board that's going to insult an attorney representing the party or a party.
Thank you.
Thank you.
I appreciate your comments on that. Do you have anything else? Will you have your client give any testimony?
Well, again, we need to determine whether we have a prima facie case.
Well, let's just...
And these are only direct questions for the officer.
I can explain why you don't have a prima facie case if you'll let me.
Sir?
You're going to decide it.
Well, that's... We'll
I'm just asking here. I'm not.
Board, if I can caution you, I think we've got some emotions flowing here. Let's take a breath. We've got to remember that due process is important here. They need an opportunity to present their case. So let's let them finish what they're entitled to do in terms of questioning the officers and presenting what other evidence they may have.
Mr. Heine, would you continue?
The reason you don't have a prima facie case because there was no indecency on the sign. I'll explain that to you. It's not enough just to say, hey, that was a kind of an offensive word. That's why this carefully written, these statutes need to be followed, and you get a chance to interpret it over and above how the police interpret it, because that's what the appellate courts, that's what the judges will do, and apparently counsel's not objecting to this argument that you get to interpret these words, correct, Mr. Levin?
That is correct.
Okay, you get to interpret these words. You don't have to accept what the officers say. In order to find a violation, prima facie, yeah, fuck you can be very offensive. Offends me. But when you hear it, they didn't raise it to get somebody aroused or display sexual. They say, well, it's a word of intensity. It's used commonly, intensity, in those examples I gave you. You not only have to find that, you have to find that the words describe sexual activities or organs in a manner offensive. You don't have to, the offense is just one of the words. Okay? Those are just words. They're not words used in this context to describe sexual activity. Think about it. Every time the F word's used, is it about sexual activity or describing it? No. It's just a word of intensity. That's the context it's taken. I didn't write the statute. They did. So they had to live by it and apply it fairly and properly in this case.
Thank you. Does the board have any questions for the officer?
Wait a minute. Officer, you referred to a memorandum. Was that distributed to everybody, all the officers in the department? A memorandum that stated...
34 pages. I'm not sure who would distribute it
Well,
to,
but
sir.
you received a copy.
Yes, sir.
And approximately how many words were on that?
There was one distinct word on there. The second word that was used and cited within that was an obvious word.
Were there any other words, or are those the only two?
There was one word cited, sir. The other C word was an obvious word that fell into that indecent speech and discussed within the agency on how to go about enforcing the sign ordinance.
So there was just one word and the other one was obvious? Is that what you're saying?
Yeah, it was an example, and then the C word is pretty obvious how it does.
Was there any attempt in the memorandum or in the training to refer to context that those words would be found objectionable? Or just the word itself, without any context, is objectionable?
Well, I will say that the F word has the power to insult and offend, and it derived from a sexual meaning.
Thank you.
Officer Gorman, I have a question.
Yes, sir.
When you approached Mr. Sheets, what was his reaction and what was his demeanor and his tone towards you?
Mr. Sheets was 100% cooperative. Mr. Sheets requested the citation, and when I left to go back to my vehicle, he said, "Come on, give me the citation." And he was cooperative the entire time.
Okay, thank you.
Any other questions from board members? If not, I'll entertain a motion as to whether or
Mr.
not...
Chairman, I'm sorry. There was a message that I was asked to take a look at. I would like to also, before you make a determination of prima facie, make an argument similar to respondents' counsel was as a sort of a closing argument of our case at this point. And that is that...
Are there going to be any more witnesses, or is this the only witness?
There's no more witnesses from the city, no.
Thank you.
Just as counsel...
We'll go do this now or at the end?
Right now.
Okay.
Just as respondents' counsel, he's not testifying, I'm not testifying, but he did say to you that he was reluctant to use the F word in this setting, and I assume, maybe I assumed incorrectly, but he was taking into consideration that this board might find that word to be offensive, and that, and it would be offensive as measured by, you know, the community that we live in. And the word itself is what was the gravamen of the offense, not the context of the word. And so the officer just testified that the word, the two words, the F word and the C word, were words that he determined based on his understanding and his training of the interpretation of the ordinance, that those two words described a sexual activity or a sexual organ. And that it was in a manner and also in a location that would be considered to be offensive, and also in a location where it would be potentially viewed by children under the age of 17. And therefore, the elements of the offense, as cited by your board's counsel, have been met in this case.
Thank you. I would entertain a motion as to whether or not the city has or has not a prima facie case.
Mr. Chair, I'd like to make a motion. I'd like to make a motion that the city has proven it has a prima facie case.
Second.
Motion's been made and seconded that the city has established a prima facie case. Any discussion on that motion? Mr. Nelson?
So, I think for the city to make the prima facie case, they have to establish that there are community standards that have been, the bounds have been stepped past. And community standards, it's a very broad, and it's up to the interpretation of, well, maybe it's the interpretation of you and me and of the officer, but the plaintiffs are also a part of the community. So how do we establish what is a prima facie case? And I spent a lot of time over the last month thinking about this. Did a lot of reading. Did a lot of reading last night because we had some new things that were brought to our attention as to what we could and could not do as a board with regards to the constitutionality of this particular ordinance, which I'm not going to opine on. But I think it's important to look at what is obscene, right, and what is indecent, and what community standards are. There's no real clear definition. But I came back to two Supreme Court cases, which I looked at, and the first one was Ruff versus the United States, 1957. The court held that material being obscene depended upon whether the average person...
I know it's...
Please don't interrupt me, sir.
I would ask the board's attorney to determine whether or not independent research and argument by a member of the board is appropriate, particularly when it's addressing, again, constitutionality of the ordinance.
I'm not addressing the constitutionality. I'm addressing what is obscene.
Well, obscene isn't even an issue before this board, so...
Well, indecent is. Indecent and obscene.
No, obscene is not before the board. Indecent is. Obscene is a separate definition, and it's not...
Are you testifying?
I'm arguing, sir, and I'm trying to make sure that the record is clear that we're not going to be considering evidence or words that were not within the charge. Otherwise, there would be a denial of due process, and I'm trying to make sure that that doesn't happen in this case.
To the extent that your discussion is regarding indecent, and whether it's your collective determination violative of the contemporary community standards, I think you can go forward. But yeah, avoid the constitutional discussions, and obscene has been clear has not been part of the charge.
Well, I'm going to continue on. And that Justice Brennan said the dominant theme of the material has to appeal to the pure in interest.
Yes, and that's the definition, Your Honor, again, that's the definition of obscenity. And if you're going to make that argument, Board Member Nicholson, you need to be fairly clear and open to what it is that you're reading from and what the definition is, and that is an obscenity case, not an indecent speech case. And again,
well,
I want to make sure
it doesn't speak only to obscenity or indecent. It speaks to community standards.
That case was an obscenity case, was it not?
All right, let's talk about Miller versus California, where Justice Berger, in the opinion of the court, said when the average person applying contemporary community standards would find the work as a whole appeals to the prurient interest.
Again, that's an obscenity case, Your Honor.
Well, it says it says community standards right in it.
It's a case interpreting in obscenity standards. That's where prurient interest comes from, as defined in our ordinance.
Thank you.
Mr. Chair.
Well, let Mr. Nelson have his chance.
Yes, thank you. And further, it goes on to say whether the work depicts or describes a sexual conduct or exploratory functions, I have trouble with that word, as defined by state law. That's very similar to language we have here. It's almost identical. But what isn't included is whether the work lacks serious literary, artistic, or political, scientific value. Only if all three
Mr. Nelson?
factors can be satisfied can the speech rise.
I think your point is, you've discussed this. The question is, do we have a prima facie case? And
I don't think the city has shown that there are any community standards.
okay, thank you. Mr. Weiner, you wanted to say something?
I wonder if I can ask for the street addresses for Mr. Sheets and Mr.
Mr. Gorman?
What?
I'm sorry, I lost my page. Mr. Sheets and Mr. Mason, sorry. Street address.
Why? The relevance?
It's relevant to what is in the document.
So we can become a target.
Are you wanting the address where the violation is there?
No, I want their street address in Punta Gorda.
Where they reside?
Yes.
Mr. Gorman wants to show his.
Yeah, I don't think that's relevant.
Okay, on page 10 of Counselor's pleading, by the fact that both parties to this case reside within Punta Gorda. I don't believe either one resides in Punta Gorda. One resides in Sarasota County, and one resides in Charlotte County. So
Let me just inject. If that's something you want to pursue when the respondent is up, you could bring it at that time. Right now, we're just dealing whether or not the city has a prima facie case. I'd like to stay with that motion.
call the question.
That motion's been seconded.
And the discussion, I hope, any other further discussion that's relevant to the motion? I'd like to have a vote on the motion. All those in favor, please signify by saying aye.
Aye.
All those opposed, say nay.
Nay.
One objection, motion passes. Respondent, would you give care to, or your counsel have anything further to add?
Mr. Sheets has a statement he would like to make. I may have a question for him, I may not, and then I would like to make a brief concluding remark.
No. May I ask one? Will this apply to all the other matters in which your client is before this board? Or do we repeat every one of them again for each of the succeeding?
I don't know that there's any uniqueness in the rest of the cases, is that correct, Mr. Levin?
Counselor, if you don't speak into that microphone, nobody's going to know what the hell you're saying.
And if I might, I think, let me just, you're asking questions of procedure, and that's fair because you may not be familiar with the procedure.
Yeah.
So the first thing that the board does is consider whether or not the city has proven a prima facie case. It's possible in many circumstances, or some circumstances, that the elements weren't proven by the facts that were presented, in which case there would be a finding that there's no prima facie case, the case ends, case dismissed. The board made a preliminary determination that there is prima facie evidence of the violation. Now, and you had the opportunity to cross-examine the witness as part of that determination. Now you have the opportunity to present your case in defense, and you will have an opportunity after you have had your questions presented to your witnesses, and I have the opportunity to cross-examination necessary, to make a closing argument at the end of your particular case. In this case that's presently open, we have to make a record for each of the citations that have been contested. unless your client wishes to dismiss the contest as it relates to the other three, the other two associated with him and whatever Mr. Massey wants to do. Otherwise, we are going to go through evidence and testimony and if necessary, argument in each of the other cases. You're welcome to incorporate by reference in the argument that you made in a previous case in the record of the case that was next call. So hopefully that answers your question, and if I misstated, hopefully the board attorney will correct me.
Yeah, I think that's a fair process since we're, we want to try to avoid duplicity here with general arguments for both sides. We can do that. But yeah, we need to get the facts.
We'll try to move through this as succinctly as possible without waiving any rights, okay? Thank you. That's my...
My name is Andrew Sheets, and yes, I have been sworn in. This is my statement for all the cases. My name is Andrew Sheets. I have been a reporter for Charlotte County Cop Watch for 9 years. I have over 200 million views online and over 200,000 subscribers online.
Man, could you just slow down a little bit so that I can understand what you're saying?
Right? You want me to repeat it?
No, but just remember, don't read so fast.
All right. And I fight government corruption and the police corruption every single day. Just like they investigate us every single day, I try to investigate them every single day. In doing that, I make record requests and go into the government offices and record video of my interaction with the people fulfilling the record request and expose the corruption. And because of this activity, the city of Punta Gorda made an illegal law 2 years ago, making it illegal to record a public official in their public place doing their public duty. They have trespassed me from everywhere. They have literally forced me into the streets to let people know of the corruption in Punta Gorda. Now the city's attempted to censor my protest speech by banning words and phrases it considers indecent. But these words express my depth of my anger and frustration with the government. And I believe it is my duty as a citizen to confront this attempt to take away our freedom of speech. Yes, I use strong words, but that is because of how bad the corruption is and how strongly I oppose the city's attempt to deprive us of our constitutional rights. I would rather use the First Amendment instead of the Second. It is not my fault I am in the street. It's your fault. You trespassed me from everywhere. And now you have made it illegal for me to protest in the street. When and where will this end? We have the right to free speech and press, and you are violating it. It's in the Constitution, and you are knowingly violating it. I was also mentioned, he wanted me to explain what my shirt was. Fuck policing for profit. It is not about sex, not even close. It is about the police literally policing for profit. Our founding fathers freed our country to be free, and now everything is illegal, and the cops are enforcing victimless crimes. We have 6 stories at the courthouse because everything's illegal. I find that appalling, and so would our founding fathers.
Mr. Sheets?
Yes.
May I ask you a question? Do you think that those words are offensive to children?
I would object to that question unless we use the whole statement under indecent. They don't just have to be offensive. The words also have to depict or describe sexual or excretory activities in organs in a manner that is offensive. If we're going to ask him that question, I would object to it being parsed in piece that reflects a total misapplication or misunderstanding of this definition. So I would object that would be questioned in that form.
If I might, and I'll let the board attorney chime in. I don't know, since you are sitting in a quasi-judicial capacity, I don't think that it's appropriate for a lawyer to object to a question that's raised by the judges in an administrative panel. But I also make the argument that asking about individual portions of the definition was what the council did with respect to our witness, and probably is fair game.
I would agree. Mr. Sheets, could you answer that question?
No, I do not. It's called the First Amendment. It's free speech. Have you ever heard of it?
Yes, sir. Thank you for your answer.
Thank you.
So I just want to reiterate that you don't think that those words are offensive to children.
It's called free speech, First Amendment.
I have no other questions.
Mr. Chair.
Yes, Mr. Weiner.
Mr. Sheets, your street address, please.
Your Honor, I'll object to that. I think that's...
Did you hear what counsel just said? You can't object to my question. Try and pay attention to what's going on.
Again, this gentleman's insulting to the attorney.
Oh, I'm not through. Believe me, I'm not through.
Go ahead and keep insulting. You're showing yourself on the record.
Mr.
Let's show a little decorum
Calm
here.
down. Yes.
Mr. Sheets, I'm going to ask one last time. Your street address.
Don't answer it.
On dangerous property and safe.
Privacy.
Mm-hmm.
I have been informed.
Okay, let me rephrase the question. You do live in Punta Gorda?
I actually live one street out of Punta Gorda in Charlotte County.
Well, Counselor's comment on page 10 was by the fact that both parties to this case reside within Punta Gorda. So either your counsel is wrong or you're wrong. I mean, you don't know where you live. You don't know where you...
Just let me just interject one thing.
What would-
May I, please?
Yes.
I do not understand the issue of what was in the pleading and the person's address. From my point of view, if I may, in the discussion, the ordinance does not apply only or against people where they live. On its face, it's applicable to any individual. And so I do not see why the gentleman has to answer with what his address is. We're interested in his conduct, not his residence.
Okay, can you in monetary fashion, that is to say, dollars and cents, how much corruption goes through the city clerk's office?
Objection, that's irrelevant, Mr. Chairman.
Why is it?
Do I get to cross-examine, or is he going to keep interrupting me?
No,
That's his job.
Noting the point previously about questions, but yeah, what is the relevance of
Mr. Sheets just said he was thrown out of all city buildings and forced into the street because of the corruption in Punta Gorda. I want to know how many dollars are spent on corrupt services in Punta Gorda that he got thrown out on the street.
Okay, in that context.
Counsel, what do I answer?
If you know, you don't know.
I do not know.
So you just say there's corruption in city clerk's office and the police department, in public works and everything else, and let it go at that?
Actually, 9 years of evidence on the Charlotte County Complex Facebook page. It's not a lie, it's real.
Wait a second, I'm sorry, but I live in Punta Gorda, and what's on Charlotte County's Facebook page doesn't affect me.
Where do you live?
You made statements that there is corruption in the city clerk's office, police department, and other agencies in the city. That's why you were thrown out on the street, because...
Mr. Weiner, can we focus on the ordinance itself? And this is it may be an interesting matter, but it's a superfluous matter for the board's purpose today. Are there any other questions for the... Are there any other questions for the respondents?
I have a question. As we've always said, the goal of this board is to provide us with a safer community that complies with all of the codes and regulations. When we're here hearing matters such as dirty roofs or et cetera, our goal is to bring people into compliance. Could these, I understand you're looking to get a message across to the people and to educate the public to what your points of view. could that just as easily be accomplished without what we perceive to be indecent speech, such as stop policing for profit, or just removing in words that may be indecent to some? You don't find them indecent, but some people do. Could you not get your point across, and we could then return to just having a community where children can walk around and look at signs? Everybody can use their definition.
Just like radio and TV, you don't have to look and listen.
I mean, that's our goal here at the community board.
May I just, in one to your statement, you don't have to look and listen. It's a little difficult to look, and when somebody has a sign in front of your face, or a TV, you have the option to turn it off. You don't have to. My other question to you is there nothing that is not protected in your view? Any language, any place, any time?
It's once you lose free speech, you're not free.
Counsel, I mean, you're not here to determine the composition of the ordinance. I think it's been more than established why he does this protest. His personal view, the extent of his belief in free speech, really has nothing on your factual determination. I wish you just could, like Mr. Levin says, let's look at that definition, and let's look at each word of the definition.
I agree with you. Thank you.
My comment was just to have a win-win for our community to just vote this.
Are there any other questions for the respondent? Yes, Mr. Weiner.
So if I understand what's going on, and I don't know whether you have one or not, not projecting, but your 6-year-old grandson can walk around with fuck grandpa on his shirt, no problem. Your sit down.
Mr. Chairman.
I understand that. We're getting to
Attorneys typically stand up in court as a show of respect to the chair. That's why I stand. I've never had a judge tell me to sit down when I stood up as a show of respect. So.
Mr. Weiner, we just temper your conduct, please.
What is it? How do you want me to rephrase that question?
It has nothing to do with the interpretation of the statute, application of the fact.
What you doing out your home has got nothing to do with
We're talking about free speech. Am I in a different room? We're talking about free speech.
in public.
We are getting a bit of feel. It is the issue of free speech, but it's speech in terms of what the ordinance is and what conduct Mr. Sheets had with it.
For the sake of the process and the efforts of the hearing, let's try to tone down our emotions.
If there's no further questions for the respondent.
I have a question for you, and then I have a closing.
Excuse me, Mr. Chair, you have asked Counselor. Thank you, sir.
Thank you very much for reminding me of that. Ms. Sheets, you'll have to come up, because I have a question for you. My question is very simple, and the answer is yes or no. The word you use on those placards, fuck you in other words, in your mind or in your intent or in your interpretation, do they in any way depict or describe sexual or excretory activities or organs?
No, it's not.
Thank you. Now I have some closing.
Well, before you do, I've got a cross-examination question.
Very well.
Forgive my language, but it's necessary in this proceeding. What does the word fuck mean to you?
Actually, it's almost a meaningless word nowadays. It used to mean, bad things before, but it's so.
What is bad thing?
I don't know.
Are you not aware that the word historically and even today refers to a sexual activity?
I did not use it as a sexual activity.
I'm not asking you that. I'm asking the word itself. How is that word defined in the word itself? What is the definition of the word fuck?
Actually, it's funny you say that. It's called flicken. It's from German. It means to strike. And in fact, another definition is for unlawful carnal knowledge.
Would you answer the question, please?
Thank you.
Rather than lecturing on historical derivation.
Correct. What again is the question?
What does the word fuck mean?
It's just a strong word when you're making a strong statement.
And you have no appreciation that it describes a sexual activity?
No.
What's the word cunt mean to you?
Another strong word which is used everywhere now, including tons of movies and TV shows.
What does it mean to you, not where it's used?
It's another, just a strong word when you're making a strong statement.
And you have no idea what the word was.
It's just another strong word when you want to make a strong statement.
You've never heard that it refers to a sexual organ?
Just another strong
No,
word.
that's not my question, sir. Have you never heard that the word cunt refers to a sexual organ?
Maybe a long time ago.
Thank you. I never heard.
Is that it?
That's it.
Anything else, Mr. Levin?
No.
I'm gonna make a little closing here, I'll try to be brief. The more attention you focus on what I'm saying and what you want to pick on me for what I'm saying, the quicker this will go. And please pay attention. I would hope and I do believe each one of you respect and honor the law. That's why you're here. You don't get to interpret the grandiose constitutional issues with the law, but you do get to determine what these words mean in common ordinary usage, and you get to apply them to this case. That's a pretty high judicial function in a way. So I want to talk mainly about that, what these words mean and how you apply, how you should apply in this particular case. Also, I want to briefly talk about community standards and what they mean, and something that really struck me as odd about the community standards argument. One thing, if you look at this ordinance, it really, if you have an area where 16-year-olds could not go and 16 and below, then this ordinance wouldn't apply. I don't think there's any public areas like that, but they put it in the ordinance. So if you had that, it wouldn't apply at all. So let's say we have a special event, you have to keep 16-year-olds out. You could hold up those signs all day long, there could be no violation. That's clear. Now, if you respect the law, you're going to say, yeah, he's right about that. So what does that mean? Who are these community standards about? That eliminates the whole community above 16. It's irrelevant, because that community is not indecent to that community. We're talking about community standards of 16 and below. Please be told what community standards they have. On the internet all the time? You hear the F-bomb dropped all the time? What are their standards? You know, nobody has talked about what these community standards are or tried to identify what this whole ordinance is about. It's about community standards below the age of 16. Yeah, well, we would like to keep our children from hearing those bad words or seeing them, hear it all the time on TV. Politicians banter about the F word. Guess what? If you go on Amazon, not Amazon, but Google, do a safe search. You put in "fuck Biden," guess what comes up? You can do it. Do it yourself. I did it. Put on safe search. It shows a page where Amazon is selling signs that says "fuck Biden." Community standards. If you go on the internet, you put in "fuck you." What do you hear? I've got it here for you. I'm not writing a song using "fuck you" words. That's on safe search. Now, do we really want to implement? Do we really want to sanitize our speech into the way we think is moral? If we can put it in the way we think are moral, somebody can come in and say, you can't use any gender words. He or she are out. You ever thought of that? If you can say this, somebody else can say that. And for long, you have to say what you have to say or you're in the poker. respect the law. I'm old school. I also said, I didn't like to hear the word because they could be considered obscene. Hey, I remember the day when if somebody cussed, they would apologize to a woman. Oh, I'm sorry I said that, man. Now the F word rolls off women's tongue like it's water. Where are the community standards here? We haven't shown any communities. We haven't even defined the relevant community. And I'm telling you, the relevant community is 16 and below. The way this is written. Think about it. Think about it. Think about it. Respect the law. And not only think about that, let's think about indecent speech, what that means. Bear me with a little folly, please. Let's read this. Indecent speech. Depict or describe sexual activity. Now, if I say, oh, what the fuck? Did anybody here think I was trying to describe sexual activity? I don't think so. I think that would be off the chart. And think if I say, what the fuck, I'm describing sexual activity. A fucking idiot, you know. Does that conjure something? No. These are just terms. When you apply this law, some of you wanted to say, look, is it obscene? Guilty. No, that's not the issue. You got to read the whole thing. If you want to honor the law, if you love the law, you'll follow the law, and you'll take every word into account. Not just ones somebody wants you to take into account, but every word into account. They don't hold up FU signs for that reason. It's just a strong expletive. That's all it is. So let's think this through. Do the right thing. Apply each word. Well, no. Let the community know you're thinking about it. Discuss it. Don't just come to a rash decision. He's not guilty. Thank you.
Chairman, I'd like to make a final closing argument, please.
Yes.
So the city council adopted this ordinance, and they carefully considered the words that are in this ordinance. Their prior ordinance made it unlawful to have obscene words on a sign. Didn't define what obscene words were. And that ordinance was adopted many years ago. The genesis of this new ordinance was actually be consistent with the provisions of relatively recent U.S. Supreme Court decision in Reed versus the city of Gilbert in Arizona.
Would this sign have been permissible under the old ordinance?
No, it would not. Excuse me, I take that back. Yes, it would, because we did not have a definition for indecent speech. So,
And we have one now?
So the genesis of this ordinance
Excuse me,
was...
Mr. Levin, we're getting into constitutional interpretation.
No, I'm not intending to interpret, and I didn't interrupt your closing argument. I appreciate the same courtesy. I'm explaining how this ordinance, contrary to what your client said in his statement, was not drafted to address him. It was actually drafted to address the U.S. Supreme Court's finding that ordinances which are content-based determinations of signs in different locations and different sizes based on content was unconstitutional. So that was the genesis of this ordinance. So when this ordinance was prepared, 99% of it addressed modifications of the existing sign code that under today's standards wouldn't meet the content-neutral standards that the U.S. Supreme Court has set forth with respect to our signs. And so, in order to address and correct the old definition that was in the ordinance of obscene to be consistent with what the U.S. Supreme Court has defined it to be, it was necessary to differentiate between different forms of speech that were determined by the courts not to be protected by the First Amendment. Indecent speech was one of them. And this definition was crafted from cases that had defined indecent speech. context, contemporary community standards, is similar. That those people that are the governing body, those people that live in the city, and those people that are selected to enforce the ordinance as police officers, and those people that tasked with the enforcement of the ordinance on the Code Enforcement Board, understand what would be considered as offensive to our community. And that's the task that the City Council placed on you without providing specific definition for community standards, because you know what is offensive and what is not offensive in our community. It may be less offensive elsewhere. And secondly, it's not the phrase that the city ordinance prohibits, it's the use of the particular words. And it's the sign that contains indecent speech, which is legible from a public right-of-way or within public space, and can be potentially viewed by children under the age of 17, which makes the violation. If the sign was displayed, for example, at one of our local drinking establishments late at night, where it's not likely that there would be children under the age of 17, then the officers in the enforcement of their responsibilities would not make a violation of the sign code under those circumstances. But the evidence before you today was that this particular sign that's in this case was being displayed in front of a county building on public property that is probably within the city of Punta Gorda, one of the most frequented buildings in the city for county services. And many of the people that come in there to renew their driver's licenses and whatever other activities that they need to do in front of the county's administrative people are going to bring children under the age of 17. Officers know that because they're familiar with how that location is utilized. So the officer who was called to the scene made the determination based on the words, the individual words on the two signs that the respondent was carrying, was that was indecent speech that would be considered to be offensive, and in a location that was a public location and potentially could be viewed by children under the age of 17. So we have satisfied the elements of this particular ordinance and would ask for a finding of violation. I would also point out that this case is, and the citation method of citing the violator is the nature of this type of case is an irreparable case. Meaning it's like the toothpaste is out of the tube. You can't put the toothpaste back in. And under statute 162 as well as our city ordinance, with respect to an irreparable violation, if you find there to be a violation and it was irreparable, under the statute in our ordinance, you can fine up to $5,000 per offense, and would ask that you consider it as an irreparable violation. Thank you, Mr. Chair.
May I briefly respond?
No, I'm sorry. I had the chance.
Generally, he brought up some new issues. All I want to say is about the penalty. These men, you know, people. First of all, none of that was what you should be.
You want to talk about penalty?
Yeah, I'll talk about the penalty.
That's what you.
Well, that's true. Thank you for correcting me that way. The penalty, the only thing that's going to stop this case is eventually, if you rule against it, you can end up determining the constitutionality. You know, all I can say is, look, honor the effort of protecting all of our constitutional rights, just not mine, but also your rights of the people that don't have legislation, that we can only speak gender-neutral words, people that want to live in a free society. Honor people that make that effort.
What are you talking about penalty?
I am.
You're going back over the speech again.
Not really. I do want to point out something. You know, I'm seeing a distinct bias here. I get picked on a lot. So did my witness. There's Diddy. I'm seeing a bias here. And I think you got to, you know, say, hey, why don't we just do our job here and rule according to the law? Let's pick out each word. Let's not be biased. So, Nancy, they're out there for all of us, really. They don't want this to be Orwellian society, especially if it goes against the grain. So why penalize them so much? Put a small penalty on there if you have to put a penalty, and let's get this thing to a different court and see what happens.
Thank you. Okay. Well, any discussion amongst the board on this?
You know, I understand him wanting to protest. I just don't, I really can't understand you wanting to use those words. You don't represent me, because I wouldn't get out, if I want to protest, I'm not gonna get out there and use inflammatory, what I feel is language. And it'd be a sad day in this country when a newborn just getting up, starting to walk, and his first words out of his mouth is F you. It'd be a sad day in this country, okay? No matter which way it goes. So, I mean, that's my opinion.
Any other comments?
Well, I look at it in two ways. The F word as used in the sign as question is used as a verb, not as an adverb, not as an adjective. It is used as a verb. The C word is used as a noun, not as an expletive, as a noun. So when you take those two things into consideration in context, they are explicitly indecent, in my opinion.
Mr. Weir?
Sure, ready for a motion.
Not yet.
Mr. Wiener, and I might suggest that you or I not make the motion, please. Because I think you and I maybe have been argumentative, and personally, I'd rather not make the motion, just.
Well, if you don't want to make the motion, that's fine, but I'd like to make the motion.
Well, we have comments. We're not done yet making comments. So, Mr. Bell?
The city has tried to draw a very fine line between indecent speech and obscene speech. And it's my opinion, right? And I'm not stating this for consideration by others, is that this case would probably, this ordinance as written would probably be found unconstitutional. That's not the question that's not what I'm stating, what I'm thinking about. I'm thinking about how much of our government, of our city's treasure do we want to spend defending this? Because it's going to go to the circuit court, district court, like the Florida Supreme Court. How much do we want to, how much do we really, how strongly do we feel about this? Can't we find a better way?
Anybody else? Well, maybe it might be one. I know myself is very concerned about community standards, but from all of my reading, as I understand it, nothing. Community standards represent the board. We are the community for Punta Gorda, and so it's not anything else. It's what it ends up, and that's the way we should treat it. And I have a problem with the use of the word the way it was described by Mr. Sheep. It does offend me. I'll say that right now. And I also found it very incredible, somewhat evasive, self-serving, and unbelievable that he did not know what the word fuck and cunt means. I just cannot believe you stood up and said that you did not know. It really questions, my view on your credibility. But the conduct was on public property. It was a sign, and I think, from my view, that I would support a motion that the respondent has violated the ordinance.
May I make that motion, Mr. Chair?
You may make, if you want to make that motion, that's fine.
Motion to find that the citation is valid and the respondent did irreparably violate Chapter 9A, Section 9A through 9A hyphen 13C 8 and Chapter 26, Section 11.5Z of the Punta Gorda Code in order that the fine in the amount of $5,000 be imposed plus case costs incurred in the amount of $7.41 in order that said fine be and case costs be paid within 10 days.
Is there a second to that motion?
Amendment, please. Would like to amend that motion, please? There's no second, you can't amend it.
No motion, no second to the motion, and the motion's flawed. Anybody else want to make another motion?
I'd like to make a motion, find that the citation is valid, respond to irreparably violate chapter 9A, section 9A-13C8, chapter 26, section 11.5B of the Punta Gorda Code, in order that a fine in the amount of $1,000 be imposed, plus case costs incurred in the amount of $7.21, in order that said fine and case costs be paid within 10 days of the entry of the year.
I'll second the motion.
Motion has been made, a second, to find that the citation is valid and the respondent has irreparably violated the said chapters. Any discussion on the motion? Vote on the motion. All those in favor of the motion as presented, please signify by saying aye.
Aye.
All those opposed?
Aye.
Nay.
So what do we have?
4 to
We guess we have
4 to 3.
Take a roll. Okay. Nora
Nay.
and Mr. Weiner?
Yes. Nay.
3 nays, 4 ayes, aye. Motion carried. Next case.
Would a short break be in order?
Yes. I think
Are you generally familiar with the city's sign standards contained in chapter 26 Punta Gorda Code?
I am.
On the screen, I show you city's exhibit number 1. And you recognize exhibit number 1 is the definition of the term sign is contained in the city's sign code.
I do.
Let's show you city's exhibit number 2. And you recognize this exhibit as the definition of the term indecent speech is contained in the city's sign code.
I do.
Now I'd like to show you exhibit number 3. You recognize exhibit number 3 as one of the types of signs prohibited by the city's sign code.
I do.
I can now show you city's exhibit number 4. Does this photo appear to be taken from your body camera?
It does.
And does the photograph appear to be an accurate depiction of the scene upon your arrival at 326 West Marion Avenue on June 14, 2021?
It does.
What building is located at 326 West Marion Avenue?
Punta Gorda City Hall.
Who is the person that's sitting on the bench in city's exhibit number 4?
Richard Lee Massey.
How do you know, how did you ascertain Mr. Massey's identity?
Upon arrival, when I got on scene there, Mr. Massey had stated that he was not going to give me his identification or means of identifying him unless there was a threat that he would be placed under arrest. I explained to Mr. Massey that at that point he was not under arrest, and I asked him if we had had any prior interactions with him. He said, probably with Lieutenant Lifter, who is one of our lieutenants on the Punta Gorda Police Department. From there, actually, it's kind of interesting. So, based off of what Massey had said to me, that gave me enough to say, okay, we may have had interaction with Mr. Massey at some point, and an intern was actually with me as well. And he had mentioned that within the last week, he believed that Mr. Massey, who I was with on this date, was in fact the same person that Lieutenant Lifter had dealt with approximately 1 week prior. From there, we go back to the patrol car, we look up the past incidents within this past week in regards to a code violation. From there, I was able to determine that Lieutenant Lifter had issued Mr. Massey 1 week prior a warning for the indecent sign. That's how I was able to obtain his identity. What I did was I ran the driver's license based off of what Lieutenant Lifter had already ascertained in his investigation from a week prior.
As you can tell from the photograph up there, I had actually pulled up Mr. Matthews' photograph from the driver's license after I had run him, and I could automatically identify him as the person that I was speaking to in person during my incident.
So-
That's how I was able to identify him.
Thank you. So please exhibit number 5, that was that taken during your determination of Mr. Mass's identification?
Yes.
Let me refer you back to exhibit 4. And what was Mr. Massey sitting in a public space?
Yes.
And what was Mr. Massey holding in his hands?
I'm just referring to my report. It's fuck Punta Gorda, trying to illegally kill free speech.
And was that, did that sign contain any indecent speech, as that term is defined by the city's sign standards?
Yes.
And specifically, what were the words on Mr. Massey's sign did you find to be indecent speech, as that term is defined in the city's sign standards?
Wow. And just to kind of go back a little bit, he also was parked in the parallel parking. I think I also notated that in my report as well. His vehicle was flying the Fuck Biden flag as well. So we have the Fuck Biden flag that's parked pretty much right in front of the city hall in the parallel parking, and then also the sign.
All right, I'm going to ask, we're going to confine ourselves to the sign that's here.
Okay. Yeah.
And what was the approximate time of day of your observations of Mr. Massey?
I responded at approximately 2:29 p.m.
And was Mr. Massey holding a sign in an area where a sign could potentially be viewed by children under the age of 17?
Yes.
And I think you mentioned, you ascertained that Mr. Massey had previously received a written warning from the city for an alleged violation of Chapter 26 of Section 11.5 of the Punta Gorda Code, is that correct?
Correct.
And I think you said Mr. Massey was issued a written warning on June 7th, 2021 for displaying a sign with indecent speech at that same location?
Correct.
What is going on here on City Exhibit number 6?
So at this point, I've identified Massey. I've typed up the violation, the ticket, the $100 fine, and I was, from what I believe, just based off of this, trying to explain to Mr. Massey the citation process, how he can pay for it if he wishes, or contest the citation.
And does this, the enlargement of this photo better show the word that you found to be in violation of the city's code?
Yeah, I can see it from here.
And I show you exhibit number 7. And ask if you can identify this exhibit.
Yes, that is.
Is that a true and accurate copy of the citation you provided to Mr. Massey on June 14th, 2021?
Yes.
Chairman, at this point, I would enter exhibits 1 through 7 into the record. I have no further questions and offer Officer Smith for cross-examination.
Officer, did you have any conversations with Mr. Massey?
Upon arrival, yes, I did.
Did he express yourself that he was there trying to defend First Amendment rights?
Along those lines, yes.
Okay, he wasn't yelling at people?
Not initially, no. He was screaming at me by the end. But no, not directly for
Talking about other people?
anybody, no.
No. He was pretty polite, no?
Yeah, absolutely.
Just an illustrative point that I want to make here. If that sign had said, what the fuck, didn't say, that was the words, would that have been a violation?
Repeat your question, I'm
If
sorry.
the sign said, "What the fuck," would that be a violation?
Yes,
Fuck off? Violation?
yes.
Just like the other case I think you set through here, you're going mainly by the memo. You're not trying to make a determination as to whether those words depict or describe sexual or exploratory activities or organs.
I would object to the form of the question. She did not testify that she relied on any memo in making the determination that the sign and the words on the sign was a violation of the rule.
I'm just trying to cut through it. Did you rely on the memo, or did you make an independent decision of what was the words that couldn't be used?
Based off of what the code ordinance has stated and the memo, we were going off of, I had made the determination that that sign was in violation of the code ordinance.
Okay. Okay. Thank you.
Just a follow-up question, if I might.
Where's the memo?
What building is depicted behind Mr. Massey in that photo, in photo number 6?
The city hall.
And what office is immediately inside the doors of the city hall? Is the city clerk's office one of the offices here inside just inside the front door?
Yes.
And have you had occasion to see members of the public come and go into the city clerk's office?
Yes.
And is that a public space?
Yes.
And is that a space where children under the age of 17 can potentially be found?
Yes, and I can actually kind of go into further as far as how I made that determination, considering that was a big discrepancy on the last one. So it's up to you.
Go ahead.
Right around the corner is actually Gilchrist Park. It's about a block away. And we see juvenile children, we see children under the age of 17, we see adults there. It's a very popular place. It's located right near the historic district and the downtown area. It's pretty centrally located in regards to that question.
And was it your determination that where Mr. Massey was, as shown in Exhibit 6, that he was in a location that was potentially within eyesight of children under the age of 17?
Yes.
Now, you considered if this sign was downtown on the streets of Punta Gorda and on the side, these type of public forums, would there be similarly a determination that 16-year-old could see it?
In downtown?
Yes.
Absolutely.
Okay. So if someone is downtown making a speech, trying to get across their First Amendment rights and use the F word making a speech, are you going to violate them for that?
I would object to the question because this is not a violation of any public speech. It is a violation of a sign code and words of concern on a sign, not a public speech.
Yeah, I'll withdraw that question. Okay.
Does the board have any questions for the officer?
I have a question for the officer. Officer, was this sign where if a 5-year-old or their parent were to walk by, would they be able to see the sign?
Well, if you kind of look in the direction of the body camera, it is close to the sidewalk. So that's really all I can attest to. I mean,
Were you offended by the word?
that's not my call, sir. Respectfully, that's not my call.
Okay, thank you. Do you think the community as a whole or as a standard would be offended by the word?
In regards to that, sir, just to throw this out there, this was not a proactive measure. This was actually a complaint-driven call. This was a complaint that came in from a community member who had seen the sign and deemed it offensive based off of what they had seen.
Thank you. One other question. You were talking about Mr. Massey's attitude when you first arrived. He was cordial or compliant with you, but then you stated as you issued him the citation, what was his demeanor?
I'll go into a little bit of that. When I first got on scene, he was cordial towards me. The only compliance issue was obviously the fact that he did not want to give me a form of identification or his identity. He asked me multiple times if he was under arrest. If that were the case, he would give me his identity. We went back and forth for a little bit. No sort of arguing or anything like that. It wasn't until after I had come back up from my car and issued the citation where he began to raise his voice. He became agitated with the incident. I gave him a ticket. I said, hey, you have 10 business days to pay this. He said, I'm not going to pay this. I'm going to wipe my ass with it. So obviously that shows kind of his agitated state. We were trying to walk away. He kept screaming at me. One of the other officers was there present as well and witnessed it and continued to do so until we ended up fully departing because of the way he was yelling. While I was in my car, I wasn't engaging with him. He was continuing to follow me to my car and then yelling at me from the sidewalk.
Thank you. Other questions?
I have one question. The address on the violation of Snicker Road in Sebring, Florida, does that appertain to the official motor vehicle record? That's his official address?
Yes, I believe. Is it in Arcadia?
It's Sebring, Florida.
Sebring, yeah. I'm not positive. I have to go back. Usually with that, it automatically populates based off of the addresses that we have on file.
Thank you.
I have a question. So when you looked at the ordinance section Z, which you cited, so did you find the language on the sign obscene?
So
again, objection. I think you're right.
Yes or no?
You're right.
So what you're asking me, in my opinion, did I find it obscene? Because I'm not attesting to my opinion. I'm attesting to the fact of what we have in front of us, the memorandums we have been issued, and whether or not that sign violated the code ordinance. My opinion, I do not attest to my opinion or anything having to do with that.
Well,
Because you're asking me, do I find?
Well, I'm asking you to say whether if he had a different sign, or instead of having the word.
Well, that's hypothetical.
With all due respect, Mr. Chairman, we're talking about obscene, we're talking about different signs. That's not the issue before the board today.
Well, it says the statute says obscene or indecent, so I'm trying to determine whether or
And
not.
the citation that was issued as reflected on the exhibit 7 and in your packet was a decent sign.
Would a sign with a raised middle finger saying that and either Trump or Bush or
Let's
would that
not get into
be indecent as well?
If you're asking me something directly related to my case, I'd be more than happy to help
May I
you.
just say, we're getting into hypotheticals, which is not really a matter of.
Well, I'm trying to establish what the community standard is.
I think
Because
we already know this.
because it says language or graphics. And in this case, it's language. We're trying to establish what community standards are. Because if we can't establish community standards.
Well, like I
you
said,
can't enforce them.
Mr. One of the reasons we responded was because of the fact that it is a complaint-driven call. Now that is us responding to investigate what this person, who the complainant was, what they found to be offensive to them, who is a part of our community.
Thank you.
Mr. Chair, there's no other questions or comments?
Just ask anybody else have anything further for the officer?
I need to follow up.
Yes, please. I'm sorry. Why are you up? Is that relevant?
Am I good to?
I'm sorry, why is that relevant if you would know the person's name?
I didn't mention the name.
If you're asking who filed the complaint, I thought you wanted the person's identity.
So one of,
Well,
if
let me,
you-
It was important to the officer that it somehow reflected the community standards. Therefore, you want to know who actually it was that put in the complaint.
I'm asking, you want the person's identity.
Basically, yes.
I can kind of go into detail how we.
Well, yeah, I want the person's identity. I thought you were
I'm not-
saying that was wrong.
Can you talk to us about
I'm not at liberty to.
promotional buy-in? There is a state statute that went into effect July 1st that prohibits the receipt of complaints in an anonymous fashion. So we have a record of who it was that initiated the complaint. However, that complaint was initiated before July 1st. And therefore, we have the ability, since it's not really relevant other than the fact that that was the reason why the officer came to the scene, as to who the complaining party was. In the future, it would be necessary for us to reveal part of the record who the complaining party was. But before July 1st, that person did have the right for protection of their privacy.
If it's, it's irrelevant who complained, that whole line of testimony about that relevant to the community's standards should be out, should have no bearing.
If you do not know who the person was that filed the complaint, that makes the complaint irrelevant. Is that your argument?
No, the officer was trying to say, there was a question about community standards. And so, well, I'll go further than that, and I'll tell you this was a called-in complaint. She was using the fact that it was called in to explain to you that the community standard was in play on this because it was a called-in complaint.
I don't believe that. She responded to a complaint after they came to the site. That was when the determination is to conduct. I believe that's what she testified to. I'm not right. But it wasn't.
She said it was called in, therefore it must have been an issue of community standards.
Mr. Chairman, I asked her whether that she found it. Obviously, she responded to that.
She found it, but he's relating the issue of the complainant. I find whether the complainant called in for whatever reason they called in and caused the officer to take action. I think we can move. I don't find that to be relevant, so move on, please.
Mr. Chairman, if I might, I don't have the authority to ask Mr. Davis to do anything, but Mr. Chairman do it. Please ask him to refrain from referring to when the word was obscene in this proceeding, because that only muddles the record. We are not making an allegation that what language on the sign was obscene. The respondent is here on an indecent side, and I think the record needs to remain clear on that. I would like to say that I was not trying to muddle the record, I was trying to clarify the record. The city is hanging its hat on indecent, not on obscene. Thank you. Mr. Chair.
Mr. Tom, are you finished? I mean, is there?
I thought somebody up here was saying something.
Well,
one last question from me. Do you recall what Mr. Massey was yelling? What specifically he was yelling, the word? The phrase he was yelling?
No, I never look at the body cams, but I don't recall verbatim.
Okay, well, we'll ask him. Thank you.
Okay.
Joanna, you have a...
I was gonna make a motion that the city's found prima facie.
Do you have any other questions of the officer from the board? No further questions? I will entertain a motion as to whether or not the city has established a prima facie case.
Mr. Chair, I'd like to make a motion that the city has proven it has a prima facie case.
Second. Motion has been made, second, that a prima facie case has been established. No. Any discussion on that?
Yes. In my view, and I'm doing this not to repeat myself, but because this is a different defendant, a different plaintiff in this case, that I don't think the city has established any community standards for determining what's indecent. And for that reason, and they have an obligation to do that. And for that reason, we think that this is not a provocation case.
Motion? I'm sorry.
Call the question.
I will. Thank you. Any other comments? None. Okay. Motion's been made. The prima facie case has been established. All those in favor of the motion, please signify by saying aye.
Aye.
All those opposed?
Nay.
Motion passes with one negative vote. Mr. Heino?
Well, thank you, board, for having me. My name is Richard Matthews, for the record.
And you've been sworn.
Yes, I have, sir. I'm here to read my statement. I was raised by strong military men. They never held back on the words they used. Yes, some words were ours. They served our country. They served this country to give me and everyone in this room to say, right in this room, to say and display what we want to say. The fundamental right protected by the First Amendment. My sign and protest was against the city's attempt to restrict the right was right down to politicality of speech. You cannot have a limit on political speech. You may not approve of my method of speech, but it's still protected under the First Amendment. I know there's a case law that covers the subject, and I will leave it to my counsel to argue the law. I am here to protect my kids' rights and everyone's in this room's rights. If we make free speech illegal, where does it stop? I want my kids to have the right to express themselves in any way they want, like I did as a kid. If one of my sons feel like they need to protest with words some consider bad or offensive, I would probably stand beside him. No questions asked. It's our right to express ourselves through speech of any type with minor limitations. I was told by the city police officer that you may have the right to say so-called bad words, which I can tell you the officer's name if you all want to know his name. He's on record saying it. You just cannot have it on a sign or a shirt. What's the difference between saying it in front of kids where they definitely can hear it versus having it on a sign where there's a chance they would not read it? Free speech is all covered by the First Amendment. That is why my father and my grandfather served this country to defend. Give me 1 second here. Change the pages. Sorry. The right to defend our rights. The city officer who took an oath to defend the Constitution, the state Constitution, then the city bylaws. So Miss Smith, taking the means she violated her oath to the Constitution of the United States of America and the Florida Constitution. I would only hope this panel would do the right thing and dismiss my ticket. My lawyer were argued all relevant case law on this matter. Thank you very much.
Does the board have any questions?
Mr. Matthews, I do have cross-examination, but
I'm so rare.
I haven't. The attorney may have some additional questions as part of the case, but certainly you can ask questions.
Okay. Thank you. Mr. Matthews, do you
I'm not saying, yeah.
I think it'd be better if we let him ask his question, and then counsel can talk to him, and then board ask questions. That's kind of like
Mr. Matthews, you heard the officer's testimony about you yelling. What were you yelling?
I was yelling for her to honor her oath to the United States Constitution. That's exactly what I was yelling.
Why is that important to you?
Because my granddaddy, as well as my father and my two stepdads, served in inside the United States services. I tried joining, but because of birth defects, I was not allowed to. Otherwise, I would be 20 years just like most of my family was. Sir.
The words you used on your sign, which says indecent speech, did you use language or graphics that depict or describe sexual or excretory activities or organs in your signs, in your opinion?
No, sir.
Do you have any intent to depict or describe sexual or excretory activities or organs in your protest?
No, sir.
And the words that you use, what to you, no matter what do they mean to you? How do you use them to express yourself?
Well, I'm going to go into a little detail. Since I was about 3 years old, I heard them words grown up by the gentlemen around. They have multiple meanings inside the U.S. language at the moment. And my use of the F word was just a use of it to pound in this city trying to kill the free speech of us. So it was just to make it punching.
Are you really frustrated with when people try to undo your free speech rights?
Yes, I am. That's why I feel 3 counties away. Come down to protest because it starts here and spreads to all communities around.
What kind of words do you use to express your frustration?
I use the word fuck. It's the word I use.
Is there other word people using that to express frustration? Anger?
Oh yeah. The first example, our Congress people tweet it out all the time. The BLM has the right to walk to walk through streets, hold up signs and yell, and there's nothing done to that. But here I'm coming down personally, one-on-one protesting, and I was fine. When there's been several protests inside the city with multiple people, none of these officers sit in this room, find them or nothing. They sat there and watched them. You're not vaccinated, a lot of them do.
No.
What's that? I am vaccinated, but I will keep the immune system, sir, so that's why I wear it. I just got out of the hospital. So I do apologize. I'm not a junkie, but I know my arms all bruised up from all the IV antibiotics I've been on.
So, Mr. Chair, I'm sorry. Kind of reached my level of confusion about 3 hours ago. So, the sign that...
Excuse me, sir, I'm in the middle of questioning this gentleman.
Please.
Forward button.
Don't become repetitive. I think they made a good point.
Sometimes I think so, but it doesn't need to be reflected in the vote.
Yeah. I'm talking about Mr. Matthew's testimony.
Thank you. So you said you had seen other people holding those colorful metaphors, which that's what we call them.
In Punta Gorda?
Yes, sir. I got video of it, sir.
And you didn't see anybody getting cited for that?
Nope. For a matter of fact, there's a protest here. We got that out of ticketed right here at City Hall. And I mentioned some of these officers and testified to it. There was at least 10 officers I counted here. Gorman was one of them. Liquor was one of them here, and guys had signs saying fuck on it. Guy had a fishing pole with fuck hanging off it, walking around with it, and none of these officers did ticket, and none of them. So, of course, I'm sitting here alone, and I have a ticket for it. Why is that? That's what I want. Yeah, and multiple people. People came inside the City Hall meeting, and they had to close down the meeting, because guys are in here yelling at them, fuck and everything else all the time. The board meeting shut down because of it, which is on video. Shut down because of it, and the officer came in and just told them, please leave. There was no tickets issued, there was no warnings issued, and none of these cases. Me and Mr. Sheets are the only ones that have tickets issued. There's a total of eight different warnings. Mr. Sheets, I believe, to this day. When there's been at least 100 people out here in the city protesting every weekend, every Friday, as well as people coming right here to City Hall where I was doing it, and no one got a ticket but me.
Thank you. I think that's your point.
Okay. Are you disabled, sir?
Yes, sir.
Were you able to pay big fines?
No, sir. I'm on a very strict limited income, sir.
You feel like if you got the big fines a lot, that's just another slap in the face to your attempt to maintain your civil rights?
Yes, sir.
Is it okay if I ask this code board not to slap you in the face with a big sign?
That's all we said.
Thank you.
Love it.
So, this is the sign on Unit 7.
Exhibit 6.
The sign uses the word fuck.
Yes, sir.
Is it your understanding that that word does not have any relation to sexual activity?
And one definition, yes, it does. But like I said, that word has many different definitions that are even in English language right now. It's used in somewhere. It's used by the President of the United States, congressmen, senators, the whole 9 yards. BLM, people protesting, and none of them mean that they want to fuck somebody.
Understood.
Sir.
Yes,
Mr. Matt, I can understand, I was in the hospital not long ago, and some of them nurses trying to get blood, they just tear you up, so I feel for you there. Let me ask you a few questions. Were you issued a warning prior to this? Okay. Now, you had said that you had noted you have camera footage of other people that were holding signs or yelling or the profanities or whatever. Do you know if they ever received one?
They have now. I got it right off the box cameras of the office on scene. And I think there was a total of 8 of us who has received warning. But all the people can't see all the fact that now you get any kind of warning. That's that.
Okay, and then the other question I have for you is, do you think that the F word would be offensive to some people in the community?
The way I was raised by the strong men around me, I would honestly say no, because my father used it since I was 3 years old.
And I understand, I can appreciate that, but do you think there would be some people in the community that would be offended?
I would guess maybe so, but on the same hand, it's the First Amendment type of word. Cohen v. California. I know y'all don't want to hear constitutional law here, but Cohen v. California covers that this place of word alone.
Okay, thank you, that's all I have.
Any other questions for the
I do for Mr. Sheets. So,
Massey.
I'm sorry, Mr. Massey. So, you state that you have video showing that other people are carrying signs after the date that this ordinance was enacted.
Yes, sir. Many videos.
Are you arguing that you're being selectively prosecuted? Have you provided this information to your attorney to present?
Yes, sir. I don't know if he has it, he's asking, but I have other attorneys that's representing me as well.
He's not supposed to talk about anything between us, that's attorney-client privilege, just so you know.
I was just trying to, because he talked about these other signs, I was trying to establish whether or not there's a claim of selective prosecution being made by either him or by you.
I'll try to address that.
I have no more questions.
Any other questions for the respondent?
Mr. Chair.
Yes, Mr. Lee.
Mr. Massey, so you made a statement that black folks were marching down the street with signs.
Yes, sir.
And to the best of my knowledge, when I viewed that parade and those signs said Black Lives Matter.
Maybe not for this town, sir, but across the country, they have.
Well, you know what? I can't be responsible for what happens in Cheyenne, Wyoming. I'm just telling you that when those people marched down the street, the sign said Black Lives Matter. What I'm asking you is the sign that says Black Lives Matter the same as Punta Gorda?
I'm going to tell you, the contents of that one sign, no. But this, like I said, BLM commonly use fuck signs all the way across the nation. Might not happen here in this town, but across the nation.
But please, we're concerned about Punta Gorda.
But,
what happens someplace else is irrelevant to this.
Actually, it is not, sir. Because it sets community standards across the nation, sir.
Well, community standards is our community here, and the ordinance is here within the city. So that's what we have to confine our attention to. Any other questions? Okay. With that,
Chair, I'll make a motion if you'd like.
sure.
Excuse me, we got a chance to sum up here.
Would you like to?
Yes, please.
Are there closing arguments in these cases,
Yes,
or not something in the code?
that would be fine.
Do you have any rebuttal?
Mr. Levin, have anything further?
I have nothing further to say other than just a reminder again, that this, we consider this to be a irreparable violation, so that the up to $5,000 per day fine will be applicable.
What I want to make again is these, the words in this ordinance matter. It doesn't really matter why they put them in there. I mean, as an adjudicative body like you are, Mr. Levin seemed to want to go through the history and put it in there for this reason, this case, this case, this case. I don't know why he said that, and then again, he didn't want you to rule on the constitutionality. The word, it doesn't matter why they're there. They're there. If I had to tell you why they were there, they're kind of pulled from the obscenity standard, really. That's in that paper that we sent. But the fact that they're there, doesn't matter why they're there. That's the way our law system is. If we don't go by the words in the statute, in order, the actual words, what do we have? Do we have a rule by law? No, we don't. We have a rule by mob. So we've got to go by the words and apply the words. It's kind of sad to me that none of you have discussed my point whatsoever, whether any of these words, as used, there's not been a single bit of discussion whether any of the words, as used, depict or describe sexual exploratory activities or organs. It's the use of the word, not the word itself, that this definition addresses. If it was just a word, it would have said, hey, you can't use the F word, you can't use the S word. No, it didn't say that. It said it leaves a decision to each case. And there ain't any discussion on it. These words like, what the fuck? Of course that's not alluding to sex. And it has become a dirty little expression. I'll say it's dirty little. I don't use it. Whether it's dirty little, that's not what you're deciding on. You're deciding the words of this statute. You're deciding whether that dirty little expression may have had its origin somewhere in a sexual activity. That's not what it means. It doesn't depict, it doesn't describe it. It's a dirty little expression. This is all it is. It's not words that describe or depict sexual activity. Dirty little expression. Ordinance doesn't overrule outlaw dirty little expression. What is a dirty little expression? Don't like it, but we can't get it out of our book. Not one of you. Excuse me?
We're talking about sign, not speech.
Same thing. We're talking about the words on the sign, that's speech. What else is it?
You talk about oral, that's all. Oral use of the word, not signage, that's all.
Words are words, whether you put them in writing or whether you speak them, they have the same import and meaning. So I don't get the point there. Now if you're saying, well, if you're alluding to the fact, well, viscerally, signs make it worse on the community, well, you may be right. You know, you may be right. But, you know, to be a civilized society, to be a law and order society, a rule of law society, we have to go by the words. I had not one person discuss those words and whether these dirty little phrases fit that definition. Not one. It seemed like you don't even care. So, why are you here if you don't care to apply the law like it's written? Why are you here? What good are you doing in this society if you don't care to apply the law like written? So rethink this, please. Sheets cares. Matthew cares. They care about First Amendment rights. Don't throw big penalties out. Let's wait and see how this thing works through.
Okay.
Chair, argument. Here's the language that's written in the ordinance. It doesn't talk about phrase in which the word appears.
That's the definition.
It talks about what is the language, or what is, whether or not the word that's used on the sign describes sexual activity in a manner that is offensive, measured by contemporary community standards.
But you haven't described.
And the prohibition is directed to signs that can be viewed by children under the age of 17. The word fuck, as used in the sign, is a word that describes sexual activity and is a manner which is offensive to those people in our community. And not just the case is made because it may offend adults. The case is made because it would be potentially viewed by children under the age of 17. Now, maybe the older the child is, the more they might be able to appreciate the context of the word. But nevertheless, there are children under the age of 17 that see the word, and that word is what we're trying, and it's those particular words that are considered to be indecent speech as defined by our city council. It would be impossible for us to list every word that may be a description of a sexual activity which may be offensive. So the ordinance defines the speech. Up to us to determine whether or not that word is, specifically you, to decide whether or not that word, not the phrase, but the word itself, describes a sexual activity in a manner that is offensive. And we submit, just as the witnesses indicated, that the word fuck does have a sexual connotation associated with it. And hopefully you'll find that that word is offensive, is measured by our community standards, and therefore constitutes indecent speech. Because there's no dispute that he didn't use that word on a sign in a public space that was viewable, potentially viewable by children under the age of 17.
Mr. Chair. Mr. Rogers, can you put up subsection D? Because, you know, we're just focusing on one part of it, and this is part of the violation.
Yes.
Any sign which contains obscene language or graphics, and any sign containing fighting words, you could take some of that, and some people could get pretty upset, and where I could see they try want to create a fight or indecent speech. So here we are, you know, put all that other stuff aside, and we still might have indecent speech, which is legible from any public right of way within public space, which can potentially be used by children under age of 17. And I agree with you 100% that as a child, that we consider anyone under 17 still a child, but I consider children even younger because they haven't been influenced by the external things that we have been influenced by. So I'd like the attorney, defense attorney, to basically focus on this, you know, whether that word is a sexual word. But in this section of our code, it doesn't have anything to do with that, whether it's what we consider obscene language, containing fighting words, indecent speech.
And just to be clear, so the due process was provided in this case. The citation was specifically identifying an indecent sign. They didn't make the allegation that it was obscene. They didn't make the allegation that it was fighting words. It was an indecent sign, and that was the testimony that was presented before you.
Any other comments or questions from the board members? If not, then I will entertain a motion to...
Mr. Chair?
Yes, Mr. Weiner.
I'll give you a motion.
Go, Mr. Weiner.
Motion to find that the citation is valid and the respondent did irreparably violate Chapter 9A, Section 9A-13, parentheses 8, and Chapter 26, Section 11.5, parentheses Z of the Punta Gorda Code, in order that the fine in the amount of $5,000 be imposed, plus case costs incurred in the amount of $7.41, and further order that said fine and case costs be paid within 10 days of the entry of this law.
Motion has been made. Respondent is in violation of citation and should pay a fine of $5,000. Is there a second to that motion? Is there a second to that motion? Motion is not carried. I'll entertain another motion.
Make a motion, please.
Please.
Motion to, excuse me, find the citation is valid and the respondent did irreparably violate Chapter 9A, Section 9A-13C8, and Chapter 26, Section 11.5Z of the Punta Gorda Code, and it is ordered that fine in the amount of $500 be imposed, plus case costs incurred in the amount of $7.41, and further ordered that said fine and case costs be paid within 10 days of the entry of this order.
Motion.
Motion.
And it's been seconded. Is there any discussion on the motion?
Yes. We're hanging our hat here on whether or not this was indecent. I think everybody knows that's not obscene. And that's been adjudicated. But we're hanging our hat on whether or not this is indecent or not. I'm just going to, something that Justice Harlan said in another case, and that this particular four-letter word, the same four-letter word, is perhaps more distasteful than others of its genre, and I agree, it is a distasteful word. But it's often true that one's man's vulgarity is another man's lyric. And this is political speech. I mean, if they had a sign that said Biden sucks, or I want to give Biden the finger, or,
Does look like that.
is this all, is this indecent? It's political speech. And I don't think the city has made the prima facie case that there's a community standard that's been violated here. We have to go back to community standard. And there is no community standard, so we can't find him guilty.
Any other discussion on the motion? I will tell you that I still believe, from my view, that this board constitutes community standards, not just like anything else. What is a reasonable man? What is the prudent? You accept it for what it is. And the defense counsel was reluctant to use the word in this forum. I know that there are people who are sensitive to that, and I find that the display, I do consider the way it was described. It wasn't like when I play golf. This was intended to express the sexual conduct. So I find it to be in violation of the ordinance. So we'll take a vote on the motion. All those in favor, please signify by saying aye.
Aye.
All those opposed?
Aye. Nay.